Idaho Matters podcast is brought to you by St. Luke's On-Demand Virtual Care, which allows patients to see a provider from their home using a computer or smartphone with on-demand care for common ailments, such as a cough, sore throat, or a sinus issue. More information at stlukesonline.org.
In collaboration with Boise State Public Radio, the Community Library presents a new podcast, Sheep Stories. I'm host Vance Cunningham. Join me as we listen through the archives of the Trailing of the Sheep Festival to learn about the Scottish, Basque, and Peruvian immigrants foundational to the sheep herding industry over the past century. Hear their stories of traveling to Idaho and learning the language of the sheep. Find Sheep Stories wherever you get your podcasts and at boisestatepublicradio.org.
From the studios of Boise State Public Radio News, I'm Gemma Gaudette. This is Idaho Matters. Next month, the 2025 Civil Liberties Symposium returns, and it's shining a spotlight on a series of legal battles that challenged injustice at the highest levels of government, centered around a series of cases. These courtroom fights overturned the wrongful convictions of 3 men who defied orders that later resulted in the mass detention of Japanese Americans during World War II. Well, now the lawyers who helped overturn those convictions are coming to Idaho to talk more about the cases and why this history still matters today. So joining us now are Lori Benai, Professor Emeritus at Seattle University School of Law, and Wendy Olson, a partner at Stoll Reeves Law Firm. I want to welcome both of you to the program.
Thank you for having us.
Thank you, Gemma.
Wendy, you're so welcome. Wendy, let me begin the conversation with you. Why did you choose to focus on these particular legal cases at this year's symposium?
Yeah, well, the symposium is sponsored by Friends of Minidoka, which has, they obviously are a nonprofit that preserves, protects, and educates about the lessons and legacy of the unjust incarceration of Japanese Americans in World War II. And so the Civil Liberties Symposiums have focused on issues related to that incarceration. And last year, it focused on trials of the Nisei. And this year, the Coram Nobis cases is the focus. And I think it's really important, and it's a good focus for 2 reasons. First, it is really, we have the opportunity to have the lawyers who argued those cases and presented those cases come and appear live in front of the audience. And it's a way to hear both the reality of how those cases worked and history come to life. And then it's also important here because of the lessons that we should have learned and need to learn about how important it is to follow due process and to have our government and its institutions present accurate facts to court, particularly when they are depriving individuals of their liberty, where we typically have a due process requirement.
Lori, can you talk to us about the cases themselves?
Absolutely. So during World War II, obviously people know that Japanese Americans were removed from the West Coast homes and incarcerated en masse in camps across the interior, including at Minidoka in Hunt, Idaho. After that, prior to the incarceration, when the orders came down, 3 men challenged the orders. Minyasui, Gordon Hirabayashi, and Fred Korematsu challenged the orders, were convicted at trial and took their cases and their challenges to the orders all the way up to the Supreme Court. And in 1943 and 1944, the U.S. Supreme Court upheld the orders that had culminated in the incarceration of Japanese Americans, which was, of course, shocking not only to these men who had faith that their convictions would be reversed, because it just seemed so blatantly unconstitutional to round up a group of people on the basis of their national origin with no evidence, no, as Wendy said, no due process, no hearings, no charges. 2/3 of them were American citizens, and to put them in these camps. So they lived with these convictions for 40 years, and the Japanese Americans lived with this for 40 years. I remember my parents were incarcerated. My parents, my grandparents, my aunts and uncles were incarcerated at Manzanar. And I remember my mother saying that it felt like there was this huge cloud of guilt kind of hanging over her during her life, although she had not done anything. She was a 16-year-old high school student when she went to camp. So 40 years passed, and in 1981, Peter Irons was a professor at UMass Amherst, and he was researching a book about the World War II lawyers involved in these cases and came across some shocking documents. Documents that he found, along with documents found by archival researcher Aiko Herzog Yoshinaga, established a couple of things. Number one, overall, that the government suppressed, altered, and destroyed material evidence while it was arguing Fred Gordon and Min's cases before the U.S. Supreme Court. For example, first, there was this report written by General DeWitt. General DeWitt was the commanding general on the West Coast, and he wrote a report explaining why he issued the orders he issued. The government had argued in these cases all along up to the Supreme Court that there was not sufficient time to separate the loyal from the disloyal. But when DeWitt wrote his report, in the report he said that his decisions were not based on lack of time. It was based on the fact that you could never tell a loyal Japanese American from a disloyal one, no matter how much time you had. Totally race-based assertion that Japanese Americans had this quality that you could never tell if they were going to be disloyal. That report was ordered destroyed and altered so that it said that there was lack of time, insufficient time to support the government's argument. The copies of the report that stated the wrong thing were burned. The soldier who burned the report did not burn one copy of the report and did not burn a copy of his memo saying he had burned the reports. Secondly, there were reports intelligence reports and the government's own intelligence reports from the FBI, the Federal Communications Commission, and the Office of Naval Intelligence that basically said that refuted DeWitt's claims of illegal short-of-ship signaling, illegal radio transmissions, and also said that any issues could be resolved on an individual basis, not a group basis. The lawyers, a couple of really incredible lawyers within in the Department of Justice said, we have to tell the court about these reports or else it will be suppression of evidence. And they were overruled. So the court never heard about those reports. So based on this evidence, legal teams were gathered to bring these petitions called writ of error quorum nobis. And we brought them in 3 different cities, San Francisco, Portland, and Seattle. And you're going to hear from the 3 of us. I was on Fred Korematsu's team. You'll hear from Peggy Nagai, who was Minya Sui's lead attorney, and my sister, Catherine Bana, who happens to be my sister, who represented Gordon Hirabayashi. And we brought these cases and were able to get these men's convictions vacated, that is, erased from their records. 2 of the judges made affirmative findings that there was government misconduct that led to the convictions.
So, Lori, with those obstacles, what obstacles did the legal teams face when you were reopening these cases?
There were several. So also keep in mind, we were young. I was 2 years out of law school when I started working on this case. So when I think about obstacles, I think that at least for me, we kind of said, well, these are from the government's own files. It's really kind of hard to imagine that we could possibly lose. Although I think we probably had our skeptics. There were a few legal issues that we had to surmount. We had to figure out what court to file in. Do we file in the Supreme Court? Do we file in the district court? We decided to file in the district courts. We needed money. This was a pro bono effort. So this was the days when you had to pay for phone calls and things like that. And so we needed money. We couldn't tell people what we were doing because we didn't want the government to start destroying documents. So we went to our parents and our friends and asked them to raise money. And we started getting $10, $25 checks to help fund this effort. So there were a few. Justice Goldberg, former Supreme Court Justice Goldberg, said that what we were doing was unwise to challenge Korematsu. So there were some barriers, but we were certainly not deterred.
So, Wendy, Why is it important for law students, but other folks, to learn more about these specific cases?
Oh, I think there are lots of reasons, one of which is the importance of lawyers in challenging unjust convictions and the creativity that you can have as a lawyer, the hard work you can undertake to find the evidence you need to support your claims. I think Lori's story of being 2 years out of law school and having an opportunity to do this should be an inspiration to law students and to lawyers and to the public. I think it's also a lesson to the public that we have to ask serious questions about what our government is choosing to do. And we have to demand that people who are in important roles of government, from generals to lawyers at the Department of Justice to justices on the Supreme Court, have an obligation to get the facts right and to use actual facts in making their decisions. I think it's also just an important history lesson for those of us in Idaho and who have had the opportunity to see the real world impacts of the mass incarceration of Japanese Americans, including, as Lori said, almost all citizens. And we have grown up with that, and we need to keep that lesson alive. I remember the first time I went to hunt camp when I was in high school. And I think that we need to keep the lessons of what happened alive. And there's no better
Mhm.
story. I mean, I think Lori highlighted some of just it's almost like a great mystery novel about how they found some of the evidence, but the hard work and the challenges and the success are an incredible story. And I'm eager to have to share that here in Idaho.
And this is for either one of you, but I'm curious to know from a legal standpoint, why do either of you think more lawyers and judges didn't speak out against the incarceration of Japanese Americans during the time that this was happening?
It was, first of all, Roosevelt was a very popular president. The National ACLU refused to take a position attacking Roosevelt's authority to issue Executive Order 9066. It did say that lawyers could say that the orders were racially applied in a racially discriminatory manner. But Roosevelt was a very popular president. It was also kind of before the civil rights movement and the civil rights era and all of these different things. Um, it was during World War II. There was a mass support of the war. But it is. I'm not saying there's. I'm not saying it was okay. It's shocking that so few people spoke out. None of the major civil rights groups spoke out against it. A few individuals, few wonderful individuals spoke out. A few small religious organizations, the Quakers, certainly helped the Japanese American community. But really, the mass majority watched it happen, and I think that that's really one of the big lessons out of this is that we need to make sure that we're vigilant. And we also have to make sure we're not silent, because I think silence really helped make this happen. There were very, very loud voices, politicians on every level of government calling for this, syndicated columnists in the major newspapers calling for this. So there were many, many loud voices calling for it and not very many voices speaking against it. And so
Mm.
I'm heartened that we're seeing more and more people speak out today to help protect vulnerable communities. And I just think it's something we need to do. And one of the most important things about the story is that we know this happened. And the government itself has recognized that what happened during World War II was wrong. And so we can take that lesson and say, let's not let that happen again.
Oh, Wendy, before we wrap up today's conversation, can you remind us when and where the symposium will be taking place? Because my understanding is it's happening over a 3-day period.
That's absolutely right. So the symposium is October 7th through 9th. It starts next Tuesday, a week from today, with a presentation at the University of Idaho College of Law, and that's a special event for the law school community. The first big public event is the following night at the Egyptian Theater. I can see the sign for it. It's beautiful, right across the street from my office, and it begins at 5:30 with a film screening of Alternative Facts: The Lies of Executive Order 9066, and then at 6:45. Catherine and Lori and Peggy will give their presentation. And I would really encourage, tickets are free. You can go on the Friends of Minidoka website and get your tickets. And then the last presentation is on October 9th, Thursday, and that's at the community library in Ketchum. And that begins, it's a lecture or a presentation beginning at 5:30. And our good friend Melissa Davlin is the moderator for both the Egyptian Theater event and the Ketchum, Idaho event. I would encourage everyone to go out and see this wonderful presentation and meet these wonderful women. They're truly incredible and heroes of the law.
Well, I want to thank both of you so much for taking time out of your busy schedules to talk to us about this. We've been speaking with Lori Benai. She is Professor Emeritus at Seattle University School of Law, and Wendy Olson, a partner at Stoll Reeves Law Firm. We've been discussing the upcoming 2025 Civil Liberties Symposium. I'm Gemma Gaudette, and this is Idaho Matters.